setting up. The final case I'll go ahead and just call is Security National Insurance Company versus Jerry Mitchell as personal representative of the estate of Destiny France, and Mark Smith as Mounts, Judy L. Mounts and Destiny P. France, and Mark P. Smith as personal representative of the estate of Maggie Laura. The number of that case is 24-2035. So council, take your time in setting up. Counsel for appellant, how much time would you like for rebuttal?
I know that there's a cross appeal, but I'm going to argue things that relate to that up front, so I think I'll save 4 minutes for rebuttal.
Whenever you're ready, counsel.
May it please the court, I'm still Chris Altenbrun, and my partner Eleanor Sills is still unavailable to attend this oral argument. But together we represent Security National Insurance Company in this case. It's important to appreciate in this case, I'm not going to go through the sad facts of this case because I think you understand them. But it's important to appreciate in this case that when the trial started in the declaratory action case, the dispositive issue for which the three estates had the burden of proof was whether Maggie Laura, not her brother Antonio, was an insured under the automobile liability section of the Security National Insurance policy that was issued on her brother's car. The liability section of this policy, and most policies, says that a person is insured because if they're legally responsible for an accident. That's why we have the liability section of the policy. Since Maggie Laura was neither the owner nor a resident relative in the owner's home, she ends up being covered by a portion of the policy that's in virtually all family auto policies, been there for years, that provides that she is an insured with respect to an accident arising out of that person's maintenance or use of your covered auto with your express and implied permission. The lawyers for the three estates have known all along that the only way that Maggie Laura could be insured under this policy would be if she was legally responsible for an accident by giving the car to Mr. Cruz. That is exactly what they alleged in each of the underlying lawsuits that caused this DEC action to be filed. That Antonio Lara gave this car to his sister Maggie, and Maggie gave it to Mr. Cruz. But proving that theory under the facts as described here, with everyone dead and all these problems, proving that it arose that she had express or implied consent is a huge task for whoever has the burden of proof. And as a result, rather early on, the lawyers for the three estates basically shifted to a theory that conflates the supposed liability of Maggie Laura with the actual liability of Antonio Laura as the owner under the dangerous instrumentality doctrine that also makes his insurance company have coverage for him, and by the way, a duty to defend the actual driver at the end of any bailment chain. They confused that with the liability for her and whether she needed to be and was covered by the Security National Insurance policy. They did this, and they continue to do this all the way through here. The reply brief that's filed in the cross appeal, the heading on the argument is Security National issued the policy covering those with implied permission, in quotes, which means any user after the owner has consented to his vehicle being used beyond his immediate control. I'm sorry, but that's not a definition of implied permission. That's been the test since the first bailment cases under the dangerous instrumentality doctrine, provided that once the owner gives it to anyone as a user that until we get to someone who's a full-blown thief, he's on the ride to be liable for whoever's driving the vehicle. And as a result, his insurance company now is also always going to put that in the policy as a form of liability for there. So this is totally conflating one version of this for the other, and it was done so that they wouldn't have to prove up that, that they had proof that Maggie was someone who had been received enough information from her brother that she could reasonably believe that he was implying that she could use this car even though she didn't have a driver's license, even though she knew she had a drug problem, even though that she had been stopped earlier supposedly driving this car without a license. We don't really know for sure whether the person who picked her up was his brother in Okeechobee County or whether it was him, but without all regard to that, they went on this whole mission to make it as if as long as he had given the car away, that was the end of this case. And that's simply not what the law is on this.
Counsel,
Yes.
the older cases on dangerous instrumentality and interpreting insurance contracts seem to focus on, say, you had in the old days a rental car company that puts something in its contract that tries to limit use so that they can then claim, well, we didn't give our permission to this downstream person.
Yeah.
And the
Yeah.
case law, generally says we have to interpret these insurance policies, or we have to interpret this contract language in light of the dangerous instrumentality doctrine and the policy behind it. We're not going to let an owner off the hook through
Right.
contract language.
Right.
Does any of that case law apply to our interpretation of the provision at issue here, which asks whether there was express or implied permission for that person's use of the car, that person meaning Maggie Laura in this case? I mean, do those dangerous instrumentality cases matter at all in interpreting this provision we're looking at?
I think the simple answer to that is no, but they successfully confused the trial judge about this entirely in this case.
So we're just looking at the plain language of the agreement and interpreting that.
Right. What the dangerous instrumentality, which I've had to deal with for about 45 years of my life, was designed so that the owner was on the hook, and that meant right away that the policy had to protect whoever was hurt, no matter who was driving. But it didn't ever say, but you can't have omnibus insureds who were conditional insureds only if they had the permission implied or express of the owner to drive the car, which is what we have here. And so all of these cases they cite, if you read through them carefully, don't really deal with that. In Chambers, for example, in Chambers versus Chandler, I'm sorry, if you look at the facts and read it through, the person that was in the chain that would be just like Maggie wasn't even a party to the lawsuit. They were just suing the driver and the company, and this was one of your fights about the rental car agreement. It's not similar at all. And so the law has never required the driver's car to actually insure someone who was driving it without his implied consent. But the dangerous instrumentality doctrine has left the driver and the insurance company on the hook for the final driver over there. The people in between normally aren't sued because they're not insured under that policy, and I don't know whether their own policies would or not. But those cases are different. And, they didn't discuss it in great detail, but you go to way back to Ray versus Earl, the case from the 2nd District in 1973, emphasizing, well, he was a passenger. Well, the facts of that case are that Mr. Earl was the plaintiff. He had been given the car by Mr. Ray. He was an express permittee, the first bailee in this chain. And he, in turn, gave it to a third person who got in an accident while Mr. Earl was a passenger, and he got hurt, and so he sued that driver. And the owner's insurance company was still insuring this because of the dangerous instrumentality and because Mr. Ray had given it to Mr. Earl in his capacity as the first permissive user of this vehicle, if you will. And so what this case held was the carrier for Mr. Ray, who pays on behalf of ultimately the final driver, is not entitled to indemnification from Mr. Earl's insurance company. They settled with Mr. Earl, and then they turned around and tried to get the money back from his own insurance company, and the second district said no. But that has little or nothing to do with the circumstances we have here. But that completely confused these cases. The first one they cite from 1967, for heaven's sakes, was a medical payments case and had alternate holdings in it. It's not something that's controlling at all.
Counsel, so under the ominous insured definition that we're working under, there has to be a connection between the liability, right, the accident arising out of the accident, right, and
Yes.
the use.
Yes.
And to do that in this case, you're gonna have to have evidence of not only an implied permission from some chain. It could be the brother to the mother to the sister, or it could be the brother to the sister. But then you have to complete the chain, do you not, and have something from the sister to the boyfriend?
Yes.
Okay.
And that was the problem here. If they really had to prove up what we started the trial with, they were going to have, we have no idea what she thought she knew.
And they selected one of those theories, did they not, in their liability action, which they got a default in?
They selected the standard chain in that lawsuit.
Which excluded the mother, right?
Then they walked away from that. And
I'll look at the DJA, I'll look at the coverage complaint again, but the coverage complaints theory excluded the mother, right? The chain was simpler, it was brother to sister to boyfriend. It may not matter.
There have been two different versions from the plaintiffs as to whether this was, the car was at the mother's house, but there's no evidence at all, and although mother was alive at the time this began, she's dead now, they never deposed her, so we don't know what her position was, but somehow the car disappears from either her house, which has been the predominant story, or possibly from Antonio Laura's house on Christmas Eve, and then is in this accident about 12:15 on Christmas Day.
But there's some cementing of the facts for which we make a coverage determination once that complaint for liability becomes a default. That has to be the facts under which the insurance company has to determine, and now for which a jury has to determine if there's coverage. It's not so much that you can change your argument midstream in the coverage action. Doesn't there have to be some cementing of the theory for which liability was ever imposed on Maggie Laura?
I believe that's correct, yes. We've got, because we're working off of judgments that were obtained based on that. They were, admittedly, that under these strange circumstances, they're default judgments, but that was the theory that no one tested in the underlying case, and that was part of what was going on here. But, since I don't want to run out of time, what I'd really like to emphasize is then, after we went through the directed verdicts and everything on this issue, suddenly we got to a change in this where what we are discussing is, oh, Judge, we've got one more jury instruction we want to use. And the instruction, which is never even filed, was use includes driving a vehicle or riding as a passenger. Now, riding as a passenger has never ever made anyone need liability insurance. It's useful for PIP or MedPay, but it's not a use that's relevant to the insurance issue that was on trial here. But they abandoned all these things that they'd been arguing up to that point in time, and they hung their hat on she was using it as a passenger. Now, they're going to tell you that we didn't preserve this. Could have done a lot better job. But the first thing an appellee needs to show you before they can start chiming on preservation is, did you give the other side a due process opportunity to prepare and respond to your argument? We're after the jury instructions have been resolved, after the DVs, which, by the way, we would have made a DV argument on this big time if we'd known about it. And so at the beginning, we did object to this, but it wasn't very articulate. But you can't expect from a preservation standpoint when they don't give you due process to have that. We came back with a motion for new trial and we laid this out. And all I'm entitled to really on this issue is a new trial. But
Counsel, it becomes very clear during the closing argument where they're going, correct? So I
Correct.
understand you sneak the jury instruction in.
Correct.
But during closing, when they start arguing their passenger theory, I see two objections in closing and not to that issue.
But that's because the judge has just given and told them that they're going to be an instruction that says that riding as a passenger is a use. So under the law that was being instructed to the jury, they were entitled to make that argument. It wasn't as a result objectionable, I don't
Counsel,
think.
what's the best case you have that we should view preservation that way? I understand that preservation should not just be a simple barrier to appellate relief, right? That's not the reason it exists, to say, done, this is easy, you didn't preserve it.
I'm not sure.
It's supposed to have a functional purpose. I've always understood the functional purpose
So-
to, go ahead.
Your Honor, I object to this argument on grounds that you shouldn't have given the jury instruction on passenger because it was incorrect. That's going to have to be the argument. I remember making something like this to Judge Terrell Hodges about 40 years ago. He told me to stop. But I don't know that there's a case dead on point on that. I mean,
Incorrect statement of the law.
yeah, but it's an incorrect statement of the law by them that you've just authorized in the jury instruction you just read to the jury.
Can we approach?
And ask for a rehearing on the jury instruction? What am I supposed to do at that point in time?
Is it just your position that you don't need to keep renewing that objection in
Yeah.
order to preserve it?
Yeah, I mean, I got to come back on
So
rehearing.
it all comes down to the specificity required during the charge conference on the new instruction.
Right, and not during the jury, well, it's really at the very conclusion of the jury conference. We're getting this to read at the very end. The jury is literally in the jury room waiting to come out to hear closing arguments when we're trying to respond to this, which is why I'm saying I don't think preservation counts here. And if preservation doesn't count, this is clearly an incorrect way to approach the case.
Is there any case which says surprise obviates preservation? Would we be, is it obvious? What is?
I think a violation of due process. I mean, if what you're setting up is a gotcha here, because if you look at the closing arguments, you know, as we've said, you know, one of the lawyers comes in and says, all we need to prove is that she had permission from her brother to ride as a passenger with a car with him or his mother or Mr. Cruz. That's it, and we win. The two estates actually went beyond that and said, well, in this case, it was Antonio Laura who gave the car to Mr. Cruz, and all she needs to be an insured for liability insurance is to be a passenger in the car that her brother gave to Mr. Cruz. Well, she's not even in the bailment chain under that. So, I mean, I've been an appellate lawyer, been a trial lawyer. To stand up and tell the judge, I'm objecting to the argument because it's based on the jury instruction you just read to the jury, I'm not going to do that. I'm not going to tell the judge I'm objecting because you're just wrong. That's implied and improper to the court. As an officer of the court, I have got to follow the law that the jury is being instructed with when I'm doing closing argument and when I object to closing arguments. I can handle it again on new trial, but I can't handle closing argument, I don't think.
So is your position that you adequately preserved it in that motion for new trial?
That's correct, only for a new trial. Now, I'm running out of time, so I'll rely on my brief on the front end issue. The front end issue was if we'd had the trial on the real issue, they could never quite prove up that Maggie had implied permission, that they were trying to use impeachment as substantive evidence, impeachment based on things from a trooper that should not have come in, when they didn't have evidence from the mother, from the neighbors, from anyone else that might support a theory that she had some reasonable belief that had implied to her that she could use his car as a drug addict with no driver's license, and on their theory, after he'd gone and picked her up someplace and on the way back and told her, no, I don't mind that you got picked and I had to come and get you, that you can go ahead and use the car. That's
Counsel, if you'd like 2 more minutes, I can add it to both sides.
Okay, thank you.
Counselor Appellee, whenever you're ready.
May it please the court, I'm Brandon Cathy. I represent the estate of Maggie Lara along with Mr. Brockmeyer, who represents the estates of Ms. Mounts and Ms. Franz, we thought if it was okay with your honors, we just divide our time 10 minutes and 10 minutes, and Mr. Brockmeyer would like 2 minutes on his cross-appeal rebuttal.
However you guys want to handle it, but you'll be in charge of keeping the time if that's okay.
Okay, thank you, Your Honor. So the first issue, the court obviously found that my client was an insured under the Security National policy. The court did that after there was a jury trial about the one issue that was in dispute between the parties for several years, which was whether or not this car was stolen by my client and her boyfriend, or whether or not they had permission to use it from Mr. Lara. That's what the dispute was at the beginning. That's what the dispute was still at the end. All three issues raised by Security National should be rejected. The case should be affirmed. The first one, it sounds like maybe Security National's conceded. It seemed like they did on page 6 of their reply that they didn't preserve any directed verdict motion on this argument that they
Counsel,
raised.
is preservation determinative of this appeal?
Yes.
If preservation is determinative of this appeal, and the jury was given instructions, which are a misstatement of the law, but we don't reach it because it wasn't preserved. There's a lot of talk in this record of a bad faith action that's going to follow your liability determination and your coverage determination. How does that affect your bad faith case?
There is no bad faith case. The lawsuit here was filed by Security National. They set the parameters of what they wanted to have determined. They wanted it determined that Maggie Lara stole the car and was not insured under their policy. They also wanted it declared that they didn't act in bad faith. They moved for summary judgment on that issue, saying that if it's a matter of law, they acted in good faith. Court said there's disputed issues of fact on both, and so now we have this second issue to be determined after this appeal is over, which is whether they acted in good faith or bad faith. But it's still part of this original declaratory action by Security National.
But
So
if
it is
the
on the table.
declaration that came out in your favor is defended simply on the fact that the errors were not preserved, are you saying that you no longer will have a bad faith case after that favorable coverage determination?
There would, to bring a bad faith case, of course, the person has to be insured under the policy, and so but that part has been determined, assuming it's affirmed, and then Ms. Lara.
But if it's affirmed only on the grounds that the errors weren't preserved, what does that ultimately do? That's my question.
I see what you're saying. If instead of affirming on the merits, it was affirmed only on preservation, what would it do? I think that what happens, it's that the declaratory judgment action that she's an insured is what's been determined, and whatever's outside of the scope of that determination is still, needs to be, if there's disputes about it, still need to be decided.
So if there's a decision that the merits, I'll withdraw my question. Go ahead, counsel.
Well, thank you, Your Honor. And so on this, I'll kind of skip ahead. I think the motion for directed verdict wasn't preserved. This idea that the plaintiffs were required here to put in, it was raised for the first time in appeal that the defendants were required to prove that Ms. Lara used the vehicle in a particular way, that she entrusted it to Mr. Cruz, that was part of what had to be proven.
Well, counsel, let me ask this. What evidence is there that Maggie Lara bailed the vehicle to Mr. Cruz?
It's inference. Similar to our permission situation here.
The inference being that she's a passenger?
No, there's more than that. We have the testimony of Mr. Antonio Lara, who is very clear. He did not give Joshua Cruz permission to use this car. So the jury can believe that. He didn't give it. So then who did? Why is he driving the car? Well, he said that the owner testified as his sister. The owner's sister is allowed to use the car. She's riding as a passenger. She's been pulled over 10 days earlier, where he shows up to the scene to retrieve his car. Never reports it's stolen. There's ample evidence there to suggest that for a jury to determine that Maggie Lara had his permission to let Joshua Cruz to use the car so long as Joshua Cruz was driving. Because who else could it be? The only person left is Maggie Lara, and it just so happens she's in the car with him at the time of the wreck. So all of that supports the inference that Joshua Cruz, if he didn't steal it and he didn't get permission from Antonio Lara, the only thing left is he got permission from the sister who's in the car with him, who's allowed to use the car when she's driving as a passenger, per Mr. Lara's testimony.
Counsel, if we look at that fact a little more closely, assuming, looking at the evidence of light most, favorable to your client, if Maggie is pulled over driving Antonio's car without a license, gets arrested, wakes him up, for whatever reason, summons him to the scene, so he has to collect the car. How does a reasonable jury infer from that that's okay with him, that she do that again sometime, or let her boyfriend take the car? I'm having trouble making that connection.
Well, there's the Christensen-Sullins case talks about this idea. They say that a failure to report the unauthorized use is evidence of the absence of conversion or theft. And so in the case, right, Security National saying it's their burden, they got to prove theft or conversion, and we have exactly that. 10 days before the wreck, he's at the scene of the wreck, doesn't report an unauthorized use, doesn't do it again on the 25th either when the police show up to his house to say, hey, my sister took my car.
Is there no middle ground or sort of gray area between permission to use a car and theft? I mean, conversion and theft I'm not even sure those are the identical concepts, but it seems like it's possible that there's something like, my sister took my car, I didn't give her permission to use it. I'm certainly not going to report it stolen, it's my sister. But it's possible for both things to be true, right? I don't consider it stolen, but I also didn't give her permission to use it.
Right. Well, going back to Roth, Susko, the Supreme Court's been at this for 70 plus years, but they've said we're not going to get into like what kind of agreements or arrangements. We don't even care if the rental agreement says you steal the car if you let someone drive it. We don't care about any of that. As soon as you let it outside of your possession, as soon as it's beyond your immediate control, permission is implied to anyone who gets that car.
But that's a dangerous instrumentality concept that
right.
Once you give permission to one, then everything
right.
downstream you're liable for. But are we there? I'll ask you the same question. Are we really in that realm interpreting this omnibus insured policy where there's no question that the owner of the car is already covered, he's liable because he's an owner, and that's addressed in the policy. So are we still in that dangerous instrumentality land where that permission is sort of, assumed, implied all the way down the line, or do we actually have to have specific evidence or, specific proof of implied permission from Antonio to Maggie? And I guess your argument would be, well, not reporting it stolen is at least some evidence of that implied permission, and that's enough for a jury to for it to go to the jury.
It's one of the pieces of evidence that allows it to go to the jury. Yes, but the Chandler versus Geico is the case we would rely on. It's a pretty recent case. It's 2012, I believe. Florida Supreme Court. They go through the whole history, Blanton, Susko, all of them, and it's important because it's against Geico and it's about coverage. And most of those other cases, they're against rental car companies, right? They're against the owner. In that case, the Supreme Court says implied permission in an insurance policy for coverage means exactly what it means under the dangerous instrumentality doctrine. We want them aligned. We've been trying to keep it aligned this whole time, and so they still are. So when you're trying to figure out if there's implied permission under an insurance policy, it's the exact same analysis. And so the fact that Antonio Lara testified he let his mom drive it the same day, it's already now a jury question, because he's given someone permission to use the car that day. And so implied permission is established. Now the burden goes to Security National. They've got to show some evidence of theft by Ms. Lara or the driver, and they weren't able to do that. The instruction on use I just wanted to talk about briefly. The instruction on use is correct, even if it had been preserved. But let me talk about the preservation quickly. First, general objection at the charge conference, just we object to it. Trial court says, do you need more time? Do you want more time? Do you want to think about it? Offers all that up. Says, no, I don't need any more time to say I object. Case goes on, an hour later or so, closing argument happens. Case ends, nothing's brought up about this. Even in the post-trial motion, and I've got to disagree with my colleague here. In the post-trial motion, there's no argument made that they should get a new trial over this use instruction. There's an argument in the motion for a new trial that they should get the entire set, the form, the burden of proof, those instructions, the things that we've been arguing about on summary judgment over and over again, that there shouldn't have been this permissive use thing, it shouldn't have been a burden shift to proof theft or conversion, and then they make one little comment where they say, and this was amplified, this error, and given the set of instructions was amplified by the use instruction. That's the closest they ever came to saying that they should get a new trial based on this instruction. So the new trial on that use instruction was not preserved because it was never argued below as a basis for a new trial. But secondly, it's an accurate, the trial court gives an instruction if it's accurate, supported by evidence, and necessary. Here it's clearly accurate. We cited the cases. I heard today it was said that it was inaccurate, but I've never seen a citation, anyone that says that use has got to be constricted to only driving. The cases, in fact, say the opposite. I'm covered, if I'm an insured, I might be covered even though I'm not liable. I've had several cases, right, where someone accused a passenger of reaching over and grabbing the wheel. So passengers can be liable for wrecks. But it might be that, well, you're covered because you were using the car. You were a passenger. You could be sleeping in the car. There's a mountain of cases about whether things arise out of the use of an auto. A kid being left in a van. All these things are use of a vehicle.
Counsel, your argument seems to disconnect the liability action from the coverage action altogether, and try to put them together for one thing and one finding. What do you say to that? You have a liability action on entrustment, correct? Right. And now we're just going on use as her as a passenger. Doesn't the omnibus insured definition require a marrying?
It doesn't.
So she could be liable for something completely opposite for which we're asking for coverage for her to be covered for.
No, she's got to be liable for a use of the vehicle. It's got to be. She has to have been using the vehicle in a way that made her liable.
But doesn't that use have to relate to what caused the accident, what the accident arose out of? Doesn't it have to be somewhat connected? She can just be sitting there.
It could be entrustment. She could grab the wheel. I mean, it could
No,
be
but entrustment is what she's liable for.
Right, but that's also that's also a use. But the policy doesn't say we only cover you if your use is entrustment. It's any use. Right, and so the definition of use was appropriate. And
but isn't that obvious under other grant of coverage provisions that counsel cited? The entire reason we're under the liability section of the policy is that she's liable, and she's liable under a theory, which you got a default judgment under, and we import that when we look at whether or not she's covered for liability based on that theory. You got a default under.
Yes, I mean we can look at the jury instruction. What was presented by Security National, one thing one had heard, and they wanted that one definition of who is an insured presented. They didn't ask about legal responsibility. They didn't want any of that. They weren't disputing any of this. They weren't disputing that she wasn't using it, that the accident arose out of her use. They agreed to that the whole case. It was not until appeal that they ever suggested in any way that they thought that her use was an issue in the case, that somehow the accident didn't arise from her use. And so the accident arose from her use because nobody disputed it. The question then just became, well, was that use one with Antonio Lara's permission? That's what was tried. So all we've had determined is, yes, the accident that arose from her use, she had permission to use the car. She is an insured, the end. There's a separate case, agreed, they were defaulted. Security National didn't get to fight about that. But they haven't been sued to pay the policy limit. They haven't been sued for breaching their duty to defend. They haven't been sued for bad faith. Right? So there's nothing in this case that ever would have resolved, in the who is an insured case, that ever would have resolved any arguments they have about whether or not she was truly liable for giving the vehicle to Mr. Cruz. And I see I'm burning through Mr. Brockmeyer's time. Thank you, Your Honors.
Good morning. May it please the Court. Alex Brockmeyer for the estate of Judy Mounts and Destiny Franz. Judge Nardella, you're right. This case can be disposed of on preservation grounds. And I do want to talk about the jury instruction issue real quick because I think there's some confusion in terms of timing of how this all went down. The use instruction came up at the very beginning of the charge conference. I was the one who was doing it. There was a good 40 plus minutes that happened from the time that we did the use instruction to where this all concluded. This wasn't a situation where we said use instruction and Judge Estrada was like, jury's coming in. If you look at the transcript, I think it's a good 50 plus pages of transcript between when the use instruction objections happen on 2566 and 2567 of the record and when the actual charge conference concludes at around record 2613. So what we'll see though then is the case that was cited in support of that use instruction was Ray versus Earl. It wasn't like this was some novel case that I brought up for the first time during this charge conference. Indeed, the the Ray versus Earl case was included in the trial court's order on implied permission and burden of proof, which was entered back in August of 2023. And the portion that I read from Ray versus Earl was pin site 70, I think it's 77 of the case, which was exactly the pin site given by the trial court on that order of burden of proof and implied permission.
Counsel, I thought the argument that was made in the initial brief was quite interesting on the fact that you never really got a determination of coverage that's pertinent. So the verdict form reads, was Maggie Laura's use of Antonio Laura's Buick on December 25th, 2018 with his implied permission? That question was answered after the jury heard a closing argument that they could determine permission just based upon her passengerhood, right? And so if that verdict was found, was Maggie Laura's use of Antonio Laura's Buick on that day with his implied permission to be a passenger, right? If the court finds that that's not enough and it has to be connected to the accident, what is your response that that's not worthless? That's not a worthless finding.
Well, my first statement on all that, Your Honor, is this chain of custody for dangerous instrumentality isn't preserved. It wasn't an argument they've ever raised at all. It never was raised at directed verdict. It wasn't raised at closing. First time I saw that argument was in the initial brief, and I thought to myself, I sat through it in a completely different trial. That question was answered based on the complaint that Security National framed the issue on. I didn't file a complaint for declaratory action. The jury answered the issue that they sought to have resolved, which was Maggie Lara's use of this vehicle with the express or implied permission of Antonio Lara. What Security National is now trying to do is rework subpart B of the omnibus insured provision in this contract and read language into it that does not exist. If it wanted a declaration that the threshold coverage grant was not satisfied here, it could have pled that, but it did not.
But for you to proceed to a bad faith case, don't you need a declaration that satisfies the fact that she's an insured? And did you get that?
Yes, we got that, and I would say to Your Honor, the issues for this court have nothing to do with bad faith. I would submit to you that's an irrelevant consideration. What should be considered is the issues that were presented on appeal, and what was presented on appeal in the first issue on appeal was not preserved. They've conceded that on page 6 of their reply brief. The second issue on appeal concerning the use instruction was not preserved as being an incorrect statement of the law, which is what they're asking you to hold on page 51 of their initial brief. The objection to the trial court, one that they clarified in an exchange with the trial court, was that it was not supported by the evidence. That is contrary to this court's decision in the Universal Property and Liberatory case, which is consistent with the Ellis v. Bohemi and Ellison v. Willoughby from the Florida Supreme Court. That was not the specific legal basis made on appeal that they made to the trial court. And so the jury answered the question that they framed. I didn't file a counterclaim. The estate of Maggie Lara didn't file a counterclaim. They asked for a declaration. They got it. They framed the issue. The jury answered it. And real quick on the cross appeal, this court doesn't have to answer it. It's moot if you guys resolve it on no preservation grounds or affirm on the direct appeal. But what I would say, and Judge Gaynham, you had asked this question about, are we looking at the policy and what does implied permission mean? And that, I agree. We're asked about what implied permission means, and Chandler answered that in the context of a liability policy. And it said quite clearly that permission means that which is the owner consenting to the vehicle being used beyond his or her, or in the context of a rental car company or an entity, its immediate control. And viewing the light and the evidence in the light most favorable to Security National. That happened here. The undisputed testimony was that in Antonio Lara, according to him, which is what Security National wants everyone to believe, was that he gave this Buick LaCrosse and its keys to his mother, Elsie Lara. That's consent to the vehicle being used beyond Antonio Lara's immediate control. That's no different than Avis Rent-A-Car giving the vehicle to Shazier and Chandler. It's no different than in Thomas versus Atlantic Associates, the business giving the vehicle to the dad, or Enterprise and Dockery giving the car to the father, or in Blanton, the dad saying to the son, you can use this car. In all those instances, the owner said to someone else, you can use this card. The consent beyond the immediate control was given, implied permission existed, and at that point, the real issue, as Dockery and Thomas explained, became one of theft or conversion. So we were entitled to that directed verdict because Antonio Lera did consent to the vehicle being used beyond his immediate control. But again, this court doesn't have to answer that if you affirm on the direct appeal. And thank you.
Probably a lot more here than I can get through in my reply, but let me start off with the fact that this concept, the deck action was purely on whether there was coverage, and it was either did she have implied permission, express permission, or whether the policy had been exhausted by payment. We never really tried exhaustion of payment in this particular case. We never alleged that she had no coverage because the vehicle had been stolen by her. That came up in a motion for summary judgment that shows up at about page 219 that they filed. And in the process of determining burden of proofs in this case, in the underlying case, because of these arguments they've made, the trial court put a burden on us that was the secondary burden to prove whether the car was stolen or not. And Judge Gannon, you're right that if the jury first finds that she has permissive use to use it, it's virtually impossible for her to be a thief. This was something that really was sort of an issue that we couldn't prove for the same reasons they couldn't prove she had implied permission. There's just not enough evidence here to do that.
Is there a way for you to win counsel through the objection that your side actually lodged at the charge conference when they initially asked for the use instruction? Because if your argument on appeal is somewhat different, I wonder if I think maybe you pointed that out in the brief. Well, they still couldn't have gone forward with what they had, like there wasn't enough.
Right.
Can you explain that? I mean, if they're not entitled to that, is there a sufficient objection that was raised? Or now would I be getting too far afield from the briefing?
I'm not sure how to answer that second part, but I mean, the front issue of this was to try to prove that what we went to trial on, they didn't prove, and that should have gotten a directed verdict on that. And admittedly, they didn't push use the way I did, but they certainly pushed implied permission, that there was no evidence of implied permission, and that's the primary problem.
I understand that, but I don't know how you work around if your argument on use wasn't preserved and it's implied permission for that use, and perhaps they've twisted the prism on use,
Right.
but it's not preserved. Doesn't your implied permission argument fall too, or can you tell me why not?
Let me fight first on if it wasn't preserved. I encourage you to simply go back and look and read the record at when and how this takes place. The discussions that had been occurring throughout this record up to that point in time, there was never an argument that all they had to prove for her to be insured for liability insurance coverage was that she was sitting in the passenger seat of the car. If that had been their argument, there would have been lots and lots of discussions on that. That comes up. I'm not exactly certain what they think's in those other 50 pages, but the opportunity to fight this ruling at that time was presented to us with about a minute to do this. And our fellows basically said, look, we object to this. We don't need this. It's not a use because, use speaks for itself, and use speaks for itself in liability coverage for something other than passenger.
But he did decline extra time to go look at it.
They did. But again, the jury's sitting we're going to wait for 2 hours and let the jury sit. I mean, it's tactics by the trial situation. They put us in a gotcha, and then they argued it, and go back and take a look at our motion for a new trial and how we added it to
Do you know where you added it? Because when you said it to me during your initial argument, my first thought was, I didn't think that was in there. But honestly, I've read a lot for today, so it was
Yes.
possible I was misremembering, but then that's what opposing counsel said.
If
Is
my
there a
notes are
record?
correct, if you look at 2843 of the record, you'll see where that's part of the new trial motion. It starts with a discussion about Emerson versus Lambert, which I'm not arguing, I was counsel of record in that, and then goes on to this and says, and this adds to the problem. So I believe it is there.
Okay, thank you, sir.
I'm just about out of time, so unless you have additional questions, I'll thank you for your attention for this day. Thank you very much.
Thank you, counsel.
Thank
I
you.
want to thank counsel for both sides. You guys are welcome to